Good morning, Madam Deputy Registrar. Are we all in place?
Yes, we are, Judge.
Would you please call the matter?
Certainly. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Belize, hearing of appeal in CCJ Appeal number 2 of 2025 between Marin and 9 other appellants, Lorna Longsword, Andrew Arnold, Laurel Brooks, Lois Garbott, Lorna Marinez, Ruthlyn Ayuso, Malin Vasquez, Guadalupe Escalante, and Curtis Kelly, and they are against Belize Telemedia Limited. The members of this morning's panel are Mr. Justice Anderson, presiding judge.
Good morning, Counsel.
Madam Justice Raj Northley.
Good morning, everyone.
Mr. Justice Barrow.
Good morning, my fellow Belizeans and all.
Mr. Justice Jamada.
Good morning to everyone.
And Mr. Justice Ebo Osuji.
Good morning to all.
May we have the appearances, please? Thank you.
May it please this honorable court, I'm Eamon Courtney. I appear for the appellants. Appearing with me are Ms. Priscilla Banner, Senior Counsel, Ms. Alison Courtney. Appearing for the respondent, Belize Telemedia Limited, are my learned friends, Mr. Fred Rumor, Senior Counsel, and Mrs. Melissa Balaramos Mala, Senior Counsel.
Thank you, Mr. Courtney. Before we begin the substantive proceedings this morning, I would like to introduce you to the newest member of our bench, Justice Chili Obu Osuji. Sorry. So we are joined for the first time by our most recently appointed judge, Justice Chili Oboyi Osuji. Justice Osuji was appointed to be a judge of this court in January 2025 by the Regional Judicial and Legal Services Commission to fill the vacancy left by the retirement of Justice Andrew Burgess. The judge was chosen following a rigorous selection process conducted by the Commission pursuant to the CCJ agreement, which authorizes appointments of applicants from a contracting party or from any part of the Commonwealth. Justice Osuji is an outstanding Nigerian jurist whose academic and professional accomplishments span 3 continents: Africa, North America, and Europe. This is not the occasion to delve into his extensive biography, which is available on our website. However, 2 of his most notable achievements could be mentioned. First, he was appointed judge of the International Criminal Court, the ICC, in The Hague in March 2012. And secondly, he served as president of that court from March 2019 to March 2021. Justice Osuji is a prolific writer who has authored 3 widely acclaimed books and numerous law journal articles in international law. In addition to bringing a wealth of experience and an outstanding work ethic to the CCJ, Justice Osuji brings great charm and a piercing intellect, both of which will be on display very shortly. Judge, on behalf of my judicial colleagues, on behalf of the entire court, I warmly welcome you to the bench and look forward to your signal contribution to the judicial work of this court. We wish you a very long and successful tenure. Thank you very much.
Thank you very much, Mr. President, for that most generous introduction. It goes without saying that it is a great honor for me to be joining you and our colleagues in the important work that this court has been doing. Thank you very much.
Thank you, Judge.
President, before we begin the substantive proceedings, I wonder if you will permit me to draw to your attention, because of my nationality, I am more early aware of it than your good selves, which is the elevation of Miss Priscilla Banner and Mrs. Melissa Balderramos Mahler to the rank of senior counsel. I would, on behalf of the panel, extend heartiest congratulations to them with your kind permission. Thank you, President.
I'm sure we fully endorse those sentiments. Congratulations, Council. I see no other pleasantries that we should engage in before we start on the substantive matter. And that being the case, I will ask, yes? I would ask Mr. Courtney whether he is willing and ready to proceed.
I am indeed ready, Your Honor, and if it may please the court, there is a minor matter of housekeeping, which is my late filing of my speaking note, for which I seek leave of the court to rely on. I do not believe that my learned friend, Mr. Lamore, has any objection to it. He has filed one, and I have no objection to his reliance thereon, if the court is prepared to grant us the indulgence.
I think the indulgence is granted based on the reaction of my colleagues.
My apologies, if I may do so on behalf of both of us. Your Honors, I had a discussion with my learned friend, Mr. Lamore, a short while ago regarding paragraph 5 of his speaking note. And as I understand it, he seeks, I sought clarification, and he is prepared to give the clarification of what it means on the record, with your permission.
So when Mr. Lumar comes to his speaking notes, you're saying that he wishes to clarify what is stated at paragraph 5, am I right?
Well, I was hoping that he would do it now so that I could tailor my submissions to.
I see.
Yes.
Mr. Lumar?
Okay. May it please the panel, in paragraph 5, as BTL, the respondent, argued before the Court of Appeal that pension that the employees were entitled after the introduction, the severance that the employees are entitled was subsumed under the pension scheme. What I'm trying to clarify is that the court found that ETL did not itemize the specific sum that constitute severance and the amount that constitute pension. The word the Court of Appeal used was, it cannot be discerned. Yes. So my paragraph 5 is to acknowledge that fact, that BTL should not have gone that route, that BTL ought to have atomized severance, which constituted part of the pension payments made to the employees.
I see. So just to get it clear, you are conceding that BTL ought to have itemized
Yes.
the contribution to pensions separate and distinct from the contributions towards severance.
Yes.
Does that satisfy you, Mr. Courtney?
Your Honor, I'm guided by my learned friend's explanation.
Thank you.
Your Honors, if I may begin, and as I understand it from the case management conference, I have 60 minutes. I will endeavor, of course, to stay within that time frame. Your Honors, what I propose to do is to start, first of all, by taking a look at the factual context as to how we arrive at a situation where there is a dispute as to whether or not severance has been paid. To secondly, take a look at the factual evidence to support our submission that in fact no severance was contributed by Belize Telemedia as a part of its contributions to the pension fund. Thirdly, I would like to take a look at section 194 and, to the extent that is necessary, section 190. And then finally, to present to your honors the basis on which we respectfully submit that the appellants are entitled to severance in this case. So if I may start by the genesis of the problem, could I invite the court's attention to page 403 of the record, which is a letter dated the 16th of February, 1995, from Ms. Loisiong Barrow, providing advice to Belize Telemedia Limited. I started at 9:11. Your Honors, the upshot of this letter is that the advice of counsel to the company is that pursuant to section 193, which is 194 now, and section 183, severance and pension benefits are alternatives. You can see that from the last sentence in the paragraph numbered 1. On page 404, counsel advises the bottom line is that there is no legal requirement to pay severance under the Labour Act or to negotiate for severance in the collective bargaining agreement, in the collective agreement. So that is the advice. The last paragraph refers to some advice that had been given by the then Solicitor General, Mr. G.N. Gandhi, to the Labour Commissioner. And I ask you to take note that the way the bundle is set up, the advice from Mr. Gandhi actually precedes this letter. It starts on page 399. There are a couple of important points. You will notice, first of all, that the letter from Ms. Young is dated February 16th, 1995, and this advice to the Labour Commissioner is 15th of February, 1995, and it is this letter that Ms. Young sends to her client. Mr. Gandhi, the Solicitor General, sets out 194 on page 399, and then at paragraph 2, he says, let me explain a history to you. It is of a historical note what he says next. Section 178. The provisions of this part of the ordinance, which apply to subsection 1 of section 178, shall cease to apply to a worker.
You're reading from the advice now?
Yes, Your Honor, on page 400 at the very top.
What paragraph of the advice you're reading from? I just want to pick it up.
My apologies.
The advice starts, I refer to our recent discussion, correct?
Yes, correct.
Yep.
Then
Where are you?
Paragraph 2, it would be of
2.
assistant.
Yeah, I got it. Good, thanks. Yeah,
Then,
thanks.
just below that, Your Honor, he's quoting from a section. And he says the provisions of this part of the ordinance which apply to subsection 1 of section 178 shall cease to apply to a worker who becomes entitled under any law now or hereafter in force to a pension, age benefit, retirement benefit, or benefit under a scheme to which the employer concerned is required to contribute. That section was in the Labour Act, which meant that as long as an employer was required to contribute to a pension scheme, the worker would no longer be entitled to severance. This section has been repealed. It is not a part of our law. Mr. Gandhi continues. He says the object of the said section 189 was to ensure that a worker would cease to be entitled to severance.
Pause. Just fill a gap for me, because you made a statement, and I'd like to get the source with the statement. You said this 189 was repealed, is no longer part of our law. Can you give us the citation for that repeal?
Your Honor, it was, I don't have the exact, well, it is, I believe, Ordinance number 4 of 1979.
Number 4 of 79. Repeal section 189, correct? That's what you're saying.
Apologies. Yeah. My apologies. If you look at paragraph 3 of the same advice, this section was repealed by Act number 7 of 1984.
All right, I got it. Yeah.
Which is where I wanted to go to, and replaced by a new section which became the present section 194. Your Honors, let me be clear. Section 189 was clear. If a pension scheme is brought in, you lose your right to severance. It was repealed by Act number 7 of 1984 and replaced by section 194. I will simply say this. In your time, you will read Mr. Gandhi's advice to the Labour Commissioner. Mr. Gandhi advises the Labour Commissioner that section 194, which replaced section 189, at paragraph 4, it will thus be seen that any retirement or other benefit under a pension or other scheme to which an employer is required to contribute is alternative to severance pay under section 183. Your Honors, with the
Mr. I'm sorry to disturb you, but before you go to 4, Mr. Gandhi tells us what is the stated object of the new section, the amendment 194, to ensure that workers do not forfeit benefits already earned. How do you see that, Mr. Courtney? What do you think Mr. Gandhi was saying to the Labour Commissioner?
Your Honor, and this is just the point I was seeking to make. Mr. Gandhi recites the purport of the amendment, which was in the long title of the bill, which was specifically to ensure that if a pension scheme is brought in, any severance that has been accrued by a worker, that worker would not forfeit the benefits already earned. And that is why our submission about 194 is backward looking and protective of that which has been earned. You will see.
So, but Mr. Just pause. Again, apologies for interrupting. By your interpretation of already earned, you translate that to mean, i.e., weeks, months served, translate into severance pay entitlement as already earned.
Yes.
And if I may add, Mr. Courtney, if I may add, and prior to the entitlement to pension.
Yes.
Is that how you see it?
Our respectful submission on 194 is that, and the language of 194 is important. What it says is your severance benefits that were earned prior or already earned, if not taken into account in the creation of the pension scheme or the collective bargaining agreement, you do not lose that. When you come to receive your payment on a 194.3 at the end of your employment, that is held for you. However, and this is where I believe my learned friend and us differ. BTL
Mr. Courtney, I just want to be very clear on what you mean. When you say that your severance pay benefits already earned, if not taken into account in a pension scheme, you do not lose that. So when you reach the end and you're getting pension, you should get in your opinion, you should get pension plus severance benefits already earned or accrued. Is that what you mean?
That is our respectful submission. And Your Honor, we make that submission, one, bearing in mind the section that was repealed. The section which was repealed would have nullified that argument. I would not be able to present that. It was repealed. Mr. Gandhi says it was replaced by 194. It was not replaced by 194. 194 came in order to ensure, as he says there, that you do not lose that which you have already earned. If it is not taken into account in the new pension scheme or the collective bargaining agreement.
Mr. Courtney, I'm really sorry, but for my own benefit, please, for clarification, pension benefits, you keep using the term already earned. Are you speaking about severance? I'm sorry, severance benefits already earned prior to the coming into effect of a new pension scheme? I need to get that clear, please.
Yes, I apologize if I said pension benefits.
No, I said severance benefits, sorry. Severance benefits already earned, yes. And I'm trying to find out, are those prior to the new pension scheme coming into play?
Yes, Your Honor. Our position is that 194 speaks in its plain language to severance benefits already earned before the implementation or introduction of a pension scheme by a company. The purpose of the section is to prevent exactly what we have here today, that a pension scheme is introduced. There are workers who have served 10 years, 15 years, or whatever it may be, who would have accrued by law severance benefits. The employer says, I am introducing a pension scheme. Under law, your severance rate accrues at 2% of your salary. Guess what? Under my pension scheme, it will be 3%. Therefore, it's better for you. And therefore, forget your severance that you have already earned, because this, going forward,
Mr. Courtney, if I may come in, I'm not sure that about the restatement of the proposition you have there. Isn't it more like the employer coming to say, well, under the severance scheme, you're entitled to, using your example, 2%, but I have a pension scheme in place to which I, the employer, contributes 3%, rather than employee pension scheme to which you'll be getting 3%. It's about the employer's contribution to that pension scheme that we should be looking at. Isn't that the way to look at it?
With respect, Your Honor, and that's the question. The law says in 183 that if you have continuous employment with a company, severance benefits are accruing over time by operation of law. The law was back in 1984 that if a pension scheme is introduced, you no longer have severance benefits. That was repealed.
But that law that was repealed, I have not seen it. If you have it on the record, you can point it out. Couldn't the concern be that the bold statement of that law might have said, well, there was severance pay, we're now introducing pension scheme. As long as we have pension scheme in place, you don't get severance pay. That would be a different result from a scenario in which the object is, well, there is severance pay, we're introducing pension scheme, but you continue to have your right to pension scheme to the extent, to severance pay, to the extent that the pension scheme does not compensate enough for the severance pay. Is that the way to look at it?
Your Honor, that is the way we believe the law exists today.
So it becomes then a matter of top up. If there's a difference between what the employee might have earned clearly under severance scheme, which does not compensate, which doesn't go as far as the pension scheme doesn't make up to. So the obligation then for the employer would be the top-up obligation, make up the difference between the two. Is that one way to look at it?
Your Honor, that is, in our respectful submission, the way to look at it. And it is for that reason that we, and I apologize for filing it lately, we filed the Florenta Rodriguez case. The Florenta Rodriguez case is from another state entity, the water company, which, and I don't ask you to turn it up at this stage, but it sets out very clearly what is severance, what is pension. And so it makes the point that the contribution by the company to the pension fund is higher than the contribution of the employee, because included in its contribution is one portion for severance, one portion for pension. My learned friend at the beginning of the hearing explained that the Court of Appeal was right, that that differentiation must always be made clear. I'm going to take
now,
the court.
Is it a question of, is it a matter of seeing the differentiation set out in, say, a tabular form, or is it a matter of a formula that may well account for the formula in a pension scheme that may well cover what might have been entitled under severance?
Your Honor, yes, I agree. It could be the formula that just explains how it's composed. And
that's what I don't mean how it's composed. A formula in the sense of, all right, it used to be only 2%, again, using your numbers. under severance scheme, but under pension scheme, I'm contributing as an employer 6% to the pension. Therefore, 6% being higher than 2%, the severance is accounted for. Is that one way to look at it? That's what I mean by formula.
Your Honor, the problem with that, although it has an elegance to its simplicity, and the facts of this case show it, when you go from that 2 to 6, the employee wants to know what is in your 6. Why? In this case, and this is why I am starting here, in this case, the pension scheme was introduced on the basis that the employer would contribute an amount equal to the employee, 3 and 3. It was then changed in 2013 to 6 and 6. Today, the collective bargaining agreement says, and I'm paraphrasing, I, employer, will contribute 8.25%. You, employee, contribute 6%, the same 2% difference. And it expressly says that included in my 8.25% is your severance. I want to wrap this up because time is against me, Your Honors. The upshot of the legal advice from counsel to the company at the time is that these two are alternatives and they rely on Section 194 to ground that opinion. We respectfully say that that opinion is wrong. They are not alternatives. And Section 194, the purport of Section 194 is to preserve the benefit of the employee that has accrued prior to the introduction of a pension scheme. One quick point to make about 194 is that the pension scheme must be a pension scheme that is required by law. The employer,
before you continue there, Mr. Courtney, please. This is not a normative question to you. Just you referred earlier to the opinion of the Solicitor General, Mr. Gian Gante. Do you accept the opinion he makes, he rendered as an interpretation of Section 194?
Mr. Gandhi is comprehensively wrong in his opinion on 194. And in fact, I want to say frontally, when you read carefully what Mr. Gandhi has written, with all due respect to him, the conclusion he arrives at is not grounded on what he says before. I leave the court with that. I just close by pointing out, Your Honors, that on page 405, there's a second opinion of Mr. Gandhi, and that is an opinion that is given months later after there has been a clarification of Section 194. For completeness, so to summarize the legal situation, in 1995, the company was advised that based on 194, severance and pension are alternatives. Your Honors, we have itemized specifically where you will see on the record that the company accepted the advice and the company memorialized in its minutes and its annual reports that we no longer pay severance based on this legal advice. When we got to trial, the witness statements changed. The company then said, oh, by the way, guess what? as a part of our contribution to the pension scheme, we have subsumed, we have included your severance payment. Your Honors, we say as a matter of fact, two things. You cannot find anywhere on a record of these proceedings an iota of evidence from Telemedia to show, to prove that it has paid $1 of severance as a part of its contribution to the pension scheme. It just simply does not exist. What does exist, Your Honor? Well, sorry, and that's the first point. The second point is, which is what I want to show now, is in fact what the record reveals is that Telemedia stopped paying severance. It commenced a pension scheme. The pension scheme was on the basis of equal contribution of the worker and the employer to the pension scheme, 3% each, and then 6% each. That began in 2013. Your Honors, there's a trust deed and rules to the pension scheme. The word severance does not appear in those documents. Those documents are dealing only with pension contributions and the rules applicable to the pension fund. The collective bargaining agreements that are on the record post 1995 do not speak to severance because it was taken out based on the advice of counsel that it's an alternative, and it is argued by Telemedia that the workers agreed to that. I submit there is no written agreement. There was no witness who came to the court below to say that the union agreed to forego severance. Let me repeat that. There is no agreement and there is no witness who testified that in 1995 the union agreed to forego severance.
Mr. Courtney, on that matter, your proposition seems to be that there was severance in prior bargaining agreements, but then after 1995, severance got removed, even under the collective bargaining agreement. Why would a union agree to concede such a benefit if we had to say, well, there's no evidence that the union agreed to it? Why would a union, for a union, workers' union, labor union, say, well, yes, our workers were enjoying this benefit all along, but we have a new agreement. That agreement has taken off this benefit. We have no problem with that.
Your Honor, we're left to speculate, but let me say this. First point, as a matter of law, and I rely on section 190 of the Labour Act, a union cannot agree in a written or other agreement to disapply section 183, which mandates by law the right of a worker to severance based on continuous employment.
So your point is, it doesn't matter what the union agreed to in that regard. It doesn't matter. It shouldn't count. That's your point.
That's my first point.
I think the point's taken, yes.
It cannot be. My second point, in answer to Your Honor's question, is that, and this is where we have to speculate in the absence of direct evidence in my submission, what likely took place, and in fact there are actual quotes which we have footnoted, that the company said, listen, your severance is accruing at 2%. We have a pension scheme. I, employer, will no longer just accrue at 2%. I will contribute 3%. You contribute 3%. At the end of your employment, you will get back your contribution, every dollar, plus the interest earned, and also my contribution and the interest earned. It is obviously going to be better for you. And speculating, the union said, wow, 3 + 3 is 6 versus 2, we win.
Now, I don't want us to get, I know I might have contributed to this 2% discussion by using using it as a reference in my question because you introduced it. Where do we get this 2% thing from, by the way?
Can I ask you to go to page 1440 of the record?
That will be the testimony of Mr. Tesukum, isn't it?
That is correct.
Where he said it's approximately 2%. I mean, it was in the middle of it. Okay. Are we bound by that, or is that a more reliable approach, or should we simply look at the scheme that the legislature set out in in section 183?
Well, Your Honor, the scheme has to go to the facts. And I submit to you that Mr. Tesukum was correct. And if you want some evidence to support that, it comes from the 2021-2024 collective bargaining agreement, where Telemedia now confesses that it is including severance, and the difference between the two is 2%, 2.25%.
This was an agreement. The CBA you're talking about that's it's now on was put in place after this litigation commenced in 2020. Is that correct?
That is correct.
Okay, thank you.
Your Honor, the actual wording I don't know if the court wants me to go first to the Tesukum cross-examination. What Mr. Tesukum says is exactly that. Severance is accruing at 2%. We are giving you 3, we are contributing 3, then we contribute 6, and therefore it's better for the workers. That is at page 1440 as his justification for why this was being done. The CBA 2021 to 2024 is to be found at page 946. And the language is, and I can read it, the union and the company agree that all employees who reach the age of 55 years shall be retired by the company and will be entitled to A, the benefits mandated by the labor laws of Belize and any other benefits covered under this agreement. Most importantly now, it adds this. The next paragraph.
Can you give me that reference again, please?
So, sorry.
Record number what? Page number.
I invite the court's attention to page 1068. Sorry. This is the 2021 to 2024 collective bargaining agreement. This language does not appear in the ones before. Rule 16, Section 16, all payments from BTL staff pension plan are subject to the staff pension plan trustee and rules. The employee agrees to contribute every month 6% of his or her monthly compensation, and the company agrees to contribute an amount equivalent to 8.25 of the employee's monthly compensation. The company and the union confirm, acknowledge, and agree that the company's 8.25% contribution in Article 16(1) above includes and takes account of any and all severance payments due and owing to the employees. What BTL is now doing is moving from the equal 3,366 contribution to the pension plan, but to add 2.25% to say that that is dealing with your severance. And Your Honor, can I ask you to take a look at give indulgence. The witness statement of Kendra Santos, which begins at page 406. She exhibits payments to workers, which is very revealing. For example, if you start, let's take an example at page 415. This is for the employee Andrew Arnold, and she sets out the details for all the workers who are appellants. And I just want to make one point, I guess, to state the obvious. If you look at page 416, she gives a breakdown of what she calls pension payment breakdown. Employee contribution, 39,381.13. Employer contribution, 39,381.13. The exact amount. They are both contributing the same amount. If the employer's contribution is 3%, and they are to contribute the same amount, it proves positive that the employer's contribution did not include severance. If it was including severance, I see Justice Osuji not following me. Let me repeat. At the time, there was a 3% contribution, employer-employee. That moved to 6% employer-employee contribution. On our case, we say that severance is accruing as a matter of law, regardless of this private agreement between the parties, and it is accruing at 2%. The case of BTL at trial is that the severance payments were included or subsumed in its contribution. And I respectfully say, if it is subsumed, then let's take the 2% as 3, then only 1% is being contributed by BTL to the pension fund, whilst the worker is contributing 3%. That is not what the pension did agree. That is not what the rules of the pension plan provide for.
So, Mr. Courtney, just to be clear, because the substantive rules declared equal contributions, you are saying to argue that the 2% is included in either the 3% or the 6% is disingenuous, because the intent of the contribution to pension was equal contributions. Is that what you're saying?
Your Honor, the word disingenuous is putting it diplomatically.
All right. Okay, good. I want to move to another point then. Good. So you agree. Good.
Yes,
when you come to 2024, hold on, and let me just make sure with the date. The 2021 to 2024 bargaining agreement, when they say the uplift of the 2.25, and that is you move from 6 to 6 each, 6 each to 6 plus 2.25, correct?
That is correct.
Are you accepting that reckoning meets the requirements of 183 and 194?
Your Honor, what I would say is this, with the greatest of respect. The language used in 16.2
Hold on. 16.2 of what? When you say 16.2, what you mean?
Of the collective bargaining agreement for 2021.
Right. Sorry, yeah. Right, yeah.
The language used, to put it in forensic language, is ambiguous, and I say deliberately so. It says the company and the union confirm, acknowledge, and agree that the company's 8.25% contribution in Article 16.1 above includes and take account of any and all severance payments due and owing to the employees. Is this forward-looking? Or is it seeking to say, I am now starting to accrue money to fund the fund for what is due and owing, as in already due and owing? It is deliberately ambiguous. Your Honors, and I say this anecdotally, and this is why we have a flood of employees coming to us now saying, wait a minute, what is happening?
All right, so Mr. Cordy, pause.
All I'm saying, Your Honor, can I just answer your question specifically? I apologize for interrupting. I just wanted to answer your question on the record. If 16.2 is understood by the company to mean that it is contributing an equal amount as the employee to the pension fund, and it is being topped up by 2.25% to accrue severance, then in my respectful submission, it satisfies the Labour Act.
Right. And that has to be reckoned, on the face of it, it ought to be reckoned prospectively, because the commitment to pay 8.25 on the face of it runs from the date of the collective agreement. But if it is a declaration that 2.25 is going to be paid over the entire period, retrospectively also, to be added on to the 6.6 and not presumed to be incorporated, you abide that. You accept that would be an acknowledgement of what the law requires.
If, as Your Honor framed it, if it is to be applied across my period of continuous employment, I abide that.
All right, good. I understand. Thank you.
If I may come in here, I want to be sure that I understand what you're saying about equal contribution. Are you saying that what nullifies the idea of the severance being incorporated in the pension contribution of the employer is the feature of the employee also being required to contribute towards his pension? Is that what you're saying? That as long as we see that the employee and the employer are contributing equally to pension, we cannot say that the employer's contribution takes care of severance. Is that what you're arguing?
Your Honor, I would put it this way, which
Okay.
will arrive at the same result. There are two things happening at the same time in our respectful submission. The first is the accrual of severance under 183 by operation of law.
Yes.
Two, there is a pension fund established by agreement between the employers and the employee of the phone company. And in that agreement, the trustees and the rules, they agree to contribute equally to the pension fund. I ask you to bear in mind, this is against legal advice that says you do not have to accrue severance. I ask you to bear in mind that the records of the company, which we have adverted to, memorialize that as of 1995, we are no longer accruing severance. And therefore that pension agreement, that pension trust deal and the rules are speaking purely of equal contribution to a pension fund. It is at trial when the challenge is raised that they change, and I emphasize that, change and say, in fact, we have subsumed it in our 3%. And when you look at the 3%, you ask yourself the question, if the deal is 3366, and you're telling me that my pension 2% is embedded in there, then you have broken the deal. We are not contributing equally to the pension fund. That is as clear as I can make it. Your Honor's time is against me. Can I just summarize the position? The facts are, and I invite the court to look at the breakdown of Ms. Santos's evidence, and you will see it stands to reason that what those documents reflect is equal contribution to the pension fund, not accounting for severance. I also ask you to look very carefully at the language used by Ms. Santos in her witness statement. She is very careful to say that this is the position of the company, as if to distance herself from it. I have also footnoted where the chief auditor and the chief accountant specifically says that as far as he is concerned, they should have been accruing severance, but we got legal advice and they said don't do it. So I follow what the company's position is. Your Honors, I have already dealt with 194 and how I believe respectfully it should be interpreted. So I don't want to, at this stage, take it any further. What I would like to spend the rest of my time on is demonstrating to the court the basis on which we say the appellants are entitled to the amounts claimed. Let me frame it this way. If the court accepts our submission that 194 of the Labour Act does not mean that severance and pension are alternatives, and that severance accrues by operation of law on the one hand, and two, the pension runs alongside it by way of the agreement. The court is with us on that. Then the next question is, well, but you have collective bargaining agreements that do not provide for severance. And our answer to that is Section 190, which says you cannot have an agreement that disapplies the operation of Section 183. And the reason for that is the unequal and imbalanced status of a worker vis-a-vis an employee. To go back to the question, why would a union say, I am foregoing severance when the law says you cannot? I respectfully submit that on the totality of the evidence, the union never ever agreed to forego severance. They agreed to a pension plan that would result in a better yield than if they only relied on severance. That's what they agreed to. Implicit in that, BTL is now saying, because we were advised that there are alternatives, and in fact, I recall, there is evidence to the effect that they actually say to the workers, we have no obligation to pay you severance. We are in fact giving you something better. There's a letter from Mr. Tessucombe to the employees, my fellow employees. We have no obligation to pay you severance. We're giving you a pension and it's better for you. So we say, if
Mr. Courtney, can I just ask you something? Is there anything in the collective agreements that say that it is agreed that severance will not be paid, or is it only that they make provision for pension, as opposed to two different things? In other words, yes. do they disapply, as it were, the entitlement to pension? Is there any evidence of that?
No, Your Honor. It's silent. They took it out.
So that is it then that the status is what the agreement was struck on was payment of pension?
That is correct.
And if one was to apply the law, that if you have to read the section and apply it purposively, would your argument be then, since there is no agreement or any statement to remove severance, but there was agreement about pension, then the party should be understood to intend to continue to apply the law, i.e., to make provision for severance?
Your Honor, I think that succinctly puts the way we would advance the argument, and we will add one element to it, which is the 2021-24 collective bargaining agreement, is that once they're challenged, they say, let us make it very clear and put it into the collective bargaining agreement. So that would be the way we put it.
Yeah, okay, thank you.
Your Honor, can I just, as I said, very quickly say, even if we are correct on these points, it still begs the critical question. Okay, Mr. Courtney, you're right. But how is it that your clients are entitled to severance today? That is in our speaking note at paragraph 10 onwards. And could I ask you to look critically at the language of the collective bargaining agreement? And this is in relation to the first 5 claimants. At page 1070 of the record, I should use the 2016. 2016. Let me be more accurate. Could I invite you to page 946 of the record? The language is the same, but the 2021 to 2024 came after these appellants left the company. So a better version is at page 946 of the record. At 17.3, retirement, the union and the company agrees that all employees who reach the age of 55 years, and this is the key, shall be retired by the company and will be entitled to the benefits mandated by the labor laws of Belize. 17.312 is not that important. 17.313, any other benefits covered under this agreement for which the employee is eligible. Your Honors, Section 183, 1 B1 provides for severance if an employee is terminated by his employer for a reason other than dismissal. We say these employees were not dismissed. We say their employment was terminated by their employer. Why do we say that? The agreement says the union and the company agrees that all employees who reach the age of 55 shall be retired by the company. This would be very different if it says who reach the age of 55 shall retire. This is an action by the company. The employee, yes, accepts and agrees that decision by the company. We respectfully submit that the Court of Appeal fell into error two ways. First of all, looking at the word terminate and saying that it must be unilateral by the company. And in fact, not the exact words, but the feeling from reading the Court of Appeal's judgment is that simply because this is in an agreement, there cannot be a termination. And we respectfully submit that an agreement does not preclude a termination by the employer under 183 1B3, 1B1.
But Mr. Courtney, just to tease that out a little bit, you see, the word terminated got some attention in the arguments, written arguments, and in the opinions. But in section 183, the word terminated is used in a few places. For example, 183 1A, employment is terminated by the employer. Just very straightforward. Then in B, the sort of parallel to 1, it is interesting that the language is different. So that, okay, if you look at the structure then, 183 1, this is a 5-year period, right? 5 to 10. And in the 5 to 10-year period, A1, are you with me?
Yes, Your Honor.
A1 says is terminated by the employer. Bam. But then when you come to 10 years and over, a parallel provision, except the difference on the face of it is 10 years and over. The same, when I say the same, a parallel B1 says terminated by the employer for reasons which do not amount to a dismissal. Then when we go to 831B3, they talk about terminated on the expiration of a period and the contract either. So therefore, terminated in, for example, B3 appears to contemplate an agreement. That is terminated on the expiration of, I'm reading this word in, an agreed contractual period, because it goes on to say, and the contract makes no provision. So one assumes that, as the first word in 3 says, that is B3, contracted for. So in the B3, we're looking at a contract and agreement, but the word terminated there has, again, it is used contextually different. And so my question really is, both to you and to counsel for the respondents, is when we come to construe 183, what are the meanings, maybe? What is the meaning of terminated as intended because of these, and I've just demonstrated a few of these nuanced usages to the words and the way they are framed. And as I try to illustrate in B3, which seems to be suggesting that terminated can also be used in the context of the legislation, where there is an agreement, a contract. So I just want to get your thoughts on that, because of course, as I said, there is some stuff in the opinions below, and of course we have something on the papers. So just your reflections on that, please.
If I may piggyback on that question, Council, for both sides. Yes, to the extent that the legislature uses the expression terminated by the employer, does it cease to be terminated by the employer if the employee agrees to it? That's one question. My second question, while at it, is Ms. Courtney mentioned how the appeals court fell into error. Is it possible that part of the difficulty the appeals court had was looking at the indication by the legislature that 60 years would be the age of retirement pursuant which certain benefits, severance, would apply? Are judges free to ignore the significance of 60 years so that people who retire before age 60 are given the same benefit that the legislature had laid down for people who retire at age 60? Thank you.
Your Honors, I will try. And in my respectful submission, the questions posed by the bench are the critical questions in answer to the claim brought by my client. Your Honor, starting at 1831A, and let me just preface this by saying, I think the juristic presupposition must be in favor of the employee, that this is social legislation and it is designed to strike a balance of fairness, equity, and fair play, and to ensure, where necessary by the legislation, that the employee is protected. Okay, 1831A, 5 to 10 years, his employment is terminated by the employer. It seems to me to be very clear. I write you a letter and say, here is your check. Do not come back to work. You go and you're terminated. But you must have accrued 5 years. And if you're in between 5 and 10 years, you get 1 week's wages for each year of service. 131B1. Over 10 years, and his employment is terminated by the employer for reasons which do not amount to dismissal. My respectful submission, the reason why the phrase which do not amount to dismissal was used there was, in a sense, to strike a balance in favor of the employer, to say to the employer that if you terminate someone at year 8, and I'm dismissing that person, i.e. I have cause, severance is not payable. And the reason for that is because we're now talking about 2 weeks wages per year. So the company is accruing a higher liability as you pass over 10 years. And so there is a balance. The legislature is saying, if you terminate, but it is not a dismissal, the worker gets the benefit. But if you have a basis on which to dismiss the person, then the severance is not payable. 3, Justice Tamadar, my respectful submission of Roman 3 is that there must be a contract. There must be some agreement. and that it is a contract for a definite period and is terminated on the expiration of such period. My respectful submission is that terminated there has to be construed to mean ended. Because it's at the expiration. In other words, it's not renewed, it's not continued. It doesn't require somebody to say, I am now terminating you, the employer to say I'm terminating you, because at the end of the contract, there will be no need for that. So the use of the word terminate there, in my respectful submission, is the contract is for a specific period, you reach that period, and you went. So that relationship is terminated in that sense.
Yes. Mr. Courtney, I think we might be running a bit short on time.
Over my time.
Just to put a fine point in it then, you're saying that the provision in the CBA, which refers to the employees reaching age 55, shall be retired by the company. That is to be taken as basically being terminated by the company or the employment contract coming to an end at the instigation of the company. Do I have that right?
That is our respectful submission, Your Honor. That is our respectful submission. We say it's either under 1 or 3. We say by the company, and you will see the analysis of Madam Justice Sonia Young, where she goes into this. The Court of Appeal does not at all address that analysis, at all. It does not look at the language used. So, Mr. President, that's the correct way we will submit it. Can I just close then by speaking to the last 5 appellants who resigned, who took what is called a voluntary retirement agreement?
Mr. Courtney, as you deal with that, could you? I'm sorry, was someone else speaking? I'm sorry, I didn't hear.
No, please go ahead. Judge.
Thank you. Mr. Courtney, as you deal with the voluntary early retirement agreement, I take it you will look at it. Just let us have your submissions on how we should look at paragraphs 5 and 6 of those agreements. I have one before me, and that is the one of Ayuso. Thank you.
I have it at page 459. She said paragraph 4 and 5 and 6. Your Honor, can I just preface what I'm about to say by asking the court to note specifically the evidence of Ms. Kendra Santos, the Chief Human Resource Officer of Telemedia. At page 408, she says specifically in paragraph 12 of her witness statement, and I quote, the 11th to 15th claimants all resigned voluntarily from their position of their own volition. That is her language. That is the evidence of the company. They have not resigned from it. If you resign after 10 years, you are entitled to a gratuity, which is equivalent to severance, 183(2). As Madam Justice Sonia Young held, I ask you to take a note that the Court of Appeal erred because they do not address this at all. They erred because the concluded wrongly that Madam Justice Young had found that these persons had retired. She said specifically that they resigned. So if the evidence of the company is uncontradicted that these employees resigned, they qualify for gratuity equivalent to pension under 183(2). Clear as day. And I say respectfully, whatever is in this voluntary retirement, early retirement agreement cannot disapply that benefit. It just simply cannot.
One small factual question.
Sorry?
Are you referring to 190 then, when you just said that?
Yes, yes.
Okay, good. All right, understood.
Very quickly, 5 and 6.
As a factual question, Mr. Courtney, factual matter again, this may be in the detail, but those who retired voluntarily pursuant to the retirement agreement, did it have anything to do with 55 years? Did they retire at 55 or not? I take it.
I don't think they were all.
That's not the case.
No, they were at different ages.
Fair enough. Thank you. Thank you.
Okay, all right.
So, Madam Justice Rastantly, the question you're posing is that paragraph 5 essentially says that you acknowledge, i.e. you employee acknowledge that the severance payments were taken into consideration as part of BTL's contribution to Belize Telemedia Staff Pension Fund, and that you attest that you have received it. Your Honor, it's simple. I can put it no differently than this. Here is your check, sign or sue. Sign or sue. And the employee signed, took the check, and is now suing. Your Honor, with the greatest of respect, it is a fact, incontrovertible, that this employee, Ms. Ayuso, did not receive her severance payment. And I go further to say, Belize Telemedia cannot point anywhere on the record to prove that they paid her severance. This is the type of agreement that the Labour Act speaks to. This is the type of agreement that the whole social ethos of labor legislation deals with, where a company says to an employee, sign this and then you get your check. If you don't sign it, you have to sue me. Your Honor, I say that insofar as these two paragraphs are concerned, the court should condemn Telemedia for including it in the agreement and should not hold it against the employee.
Thank you. Was there anything further? I think that is very comprehensive. We follow you very clearly. And as I said, time has gone. Thank you very much for those submissions, Mr. Courtney.
I'm deeply obliged, Your Honors, and thank you for affording me to go over my 1 hour.
Yes, by 10 minutes. I'm sure Mr. Loomer is aware of that. Mr. Loomer, the floor is yours. Thanks.
Thank you. Your Honors, the main planks of our submission is on 2 legs. The first one is that the case that BTL or the respondent met or brought the claim of the employees which BTL responded to is defined and refined in the reply to defense is refined in the reply of the employees, the appellants. And also, as the Court of Appeal stated in paragraph 3 of its decision, the court identified in the judgment, in paragraph 3 of the decision, the factual context or the facts which are not in dispute between the parties. And the court proceeded to hear the appeal on those factual contexts which were identified. Those issues in paragraph 3 to 4 of the decision of the Court of Appeal is clear that the parties have no dispute concerning any of those issues. Your Honors, that paragraph 3 of the decision of the Court of Appeal
Mr. Lumor, it may be helpful if you could locate us either in your speaking notes or
Yes.
your submissions.
Yeah, sure. Mhm. Your Honors, at page 22 of the records,
Right.
page 22. Your Honors will find the caption, agreed factual background. And under that, you have paragraph 3. And there, the Court of Appeal say, in a document titled Agreed Statement of Facts and Issues, dated 30th November 2021, and signed by counsel on both sides, the parties agreed the following facts. 1, Marin and others are former employees of BTL. None of the parties is denied that. 2, that the retirement age of employees of BTL is 55 years. That, the Court of Appeal finds, is not a fact in dispute between the appellant and the respondents.
Right.
And Roman 3, say for those within Marin and others who retired or resigned before 18th April 2018, employees of BTL enjoy the benefits of a collective bargaining agreement between the Belize Communication Workers Union and BTL, which they call the CBA, dated 18th April 2018, under which the parties mutually agreed to fulfill the terms of the CBA. Roman 4, those within Marin and others who retired or resigned prior to 2018 CBA enjoy the benefits of the CBA between the union and BTL as follows: 1991 to 1993, 1993 to 1995, 1999 to 2001, and 2013 to 2016, they say applicable to the third and seventh respondents. Roman 5, the CBA, which predated 2018, also provided that the retirement age of BTL was 55. 2018 CBA expressly provided that all BTL employees who reach the age of 55 shall retire and will be entitled to the benefits mandated by the Labour Act of Belize. Roman 7. The Labour Act defines the law for determining the payment of severance upon cessation of employment. And Roman 8, that Marin and others participated in and benefited from BTL pension plan. The employees, all of whom had more than 10 years service, fell into 3 classes. Roman 1, retirees, that is Appellant 1 to 5. Those retiring pursuant to the terms of the CBA having reached the age of retirement of 55 years. And 2, the resignees, 6 to 10 respondents, those resigning from BTL. And 3, the voluntary retirees, 11 to 15 respondents, those agreeing to take voluntary early retirement package offered by BTL under a retirement agreement. So those facts, the Court of Appeal noted, was agreed to by the appellant and the respondent, has not been in dispute.
Mr. Lamont,
Yes.
I'm interested in knowing the genesis of retirement age of 55, how it made it into the policy or the ecosystem, as it were, of BTL.
Yes.
Whose idea was that? Where is it coming from? And if you may also tell me, if you can, what is the retirement age in the public sector in Belize, whether that has any correlation to this 55 years?
The genesis of the 55 years is as a result of what they call union and employer negotiations, which they do every 3 years.
Was it the union that proposed it, that said workers want to go at 55, so let's put it in there? Or was it the employer that said, look, we want people to clear out at 55?
It is always very difficult because some of those issues, if not agreed, provokes industrial action. So if it is in the agreement, my assumption is that it is agreed to by the employer and the employee. Because once it is not agreed, it becomes a subject of contention and becomes a subject of labor dispute.
So you don't know who introduced it, who broached it. You do not know who broached the idea. Somebody has to have broached it.
Somebody has to broach it. Because if you have to leave your employer earlier than 60 in order to enjoy benefits, I don't think it will be coming from the employer. It will be coming from the employee.
Now, what is the public sector retirement age in Belize? Do you know?
60 years.
60 years.
Yes.
60. Was it ever 55?
No, sorry, 55 years. 55 years. To get social
it is
security
55 years.
Yes.
All right. Now, the question here, and I'll leave it for now, is this. Again, I've indicated what might have been the dilemma of the Court of Appeal in relation to age 60.
Yes.
I asked that question of Mr. Courtney. Now, the converse of that question to you is, does 60 years retirement indicated in Section 183 no longer matter? So that if the legislature took the time to indicate 60 years as age when you reach and retire, is an employer free to drop that age down to 55 and avoid the obligations that the legislature had imposed for people who retire at age 60. So employer says, all right, we want to drop this retirement age down to 55 so people don't get to age 60. Would the employer be free to say, sorry, we pulled it down, but sorry, you can go and you're not entitled to the benefits of those who returned 60? That may be the problem I see with the High Court judge that made her construe the whole thing as termination, or the retirement, compulsory retirement at 55 as termination.
Your Honor, the safest response I can give as an answer is that to go back to section 194(3) of the Labour Act, which I think will answer that question. Because section 194(3) says that for the avoidance of doubt, it is declared that the liability of the employer to pay severance pay arises on the date of cessation of work by the employee in the circumstances set out in section 183.
That is 60 years, including 60 years.
Yes. Or in any collective agreement, or in any contract of service.
Mr. Lumor, I'm glad you mentioned severance because
yeah,
I think that's where the real issue is.
Yes.
I am not sure the other side disputes any of the agreed facts that you recited earlier, but I think what they're saying is that the pension or the benefits, pension benefits, did not include severance, and it should have by virtue of the Labour Act. How do you respond to that?
Your Honor, my response is very simple. I would have to take a step backwards in order to answer that question, because it will be clearer if I take a step backwards, because what has happened in this case is that it is agreed by all the employees that before the introduction of pension, before the introduction of a pension scheme, all employees were paid severance entitlement. Nobody was left without payment. So the question of severance now is whether BTL paid severance when the employees were enjoying pension benefits.
Yes.
And your honors will see the defense of BTL that, yes, they were paid severance and it was subsumed in the pension payment. And the Court of Appeal disagreed that you need to itemize or identify, or the severance payment must be discernible. And BTL could not do it. So in respect of those who resigned, BTL was ordered to pay the severance payments due to them. My answer to the other employees is that if you say you're entitled to severance, you have to show the court the subsection of section 183, which entitles you to severance, or you have to show the court the collective bargaining agreement, which entitles you to severance, or the contract of employment, a contract of service, which entitles you to severance. So this, to end my answer is that if one looks at section 194, subsection 1 and subsection 2, BTL is still under obligation to pay severance despite the existence of a pension scheme, unless BTL can show that severance form was used as part of the benefits under the pension scheme. If you can't do that, then you need to show or itemize the severance which was due. As I want to repeat, and I want to repeat it again, it is not the argument, I was not the defense of BTL at first instance or on appeal, that because that there are alternatives, that you either get pension benefits or you get severance.
So, Mr. Lumo, just to be clear, the alternative argument that you got advice on back in the day, you accept that that was bad advice.
Bad advice.
Yes. So that you accept that under 194 you must pay both, but what you say is there is no duty on you to itemize it if you can show, as you say you can, because severance is 2% and you were paying 3 or 6 and then 8.25. If you can show that, to be factual, the 2% is subsumed within your contribution for pension, and you say that is a fortiori because 3 is larger than 2, 6 is larger than 2, and 8.25 is certainly larger than 2. Correct?
Correct.
Right. All right. So let's stay with that a little bit.
Yes.
If the pension agreement struck, as is the evidence says, that the pension is going to be payable on equal contributions.
Yes.
Before 2021 to 2024 with the 8.25, how do you make a credible, how do we make a credible assessment that the 3366, when the agreement said those are equal contributions to pension, included severance? Forget the math.
Yes.
Forget the math for now, because obviously 3 is more than 2 and 6 is more than 2, obviously. When the language says each party is making equal contributions to pension, how do you make an argument that your contribution to pension including severance when you never say that at that point?
Your Honor, if, as you said, there is equal contribution coming from employer and employee, then BTL under those circumstances will not be able or be in a position to be able to say, I can itemize.
No, I'm not on the itemizing. I get that.
Yeah.
I'm on the subsuming part because you have 2 points.
Yes.
Your point, what I understand you to be saying is this: there is no need to itemize if you can show that it is subsumed.
Yes.
And you say on the evidence before 2021 to 2024, it is subsumed because mathematically 3 is more than 2, 6 is more than 2. So therefore the 2% is subsumed. My question to you, I get all of that. My question is this: when the agreement says the language is equal contributions to pension, how can you at the same time say the contribution you made was to pension and severance?
That argument cannot be made.
So therefore, prior to 21-24, would you accept that the contributions to pension by the company did not include a contribution to severance?
Where the contributions are equal,
yes,
then there is no contribution to severance.
So prior to 2021, You accept there was no contribution to severance
Severance.
on the
Yes.
facts of this case. You accept
On the
that.
facts. Yes.
All right. Okay. Okay, good. When
That
it
being the-
comes to sorry,
No,
sorry,
please,
President.
no.
No,
Go
no,
ahead,
no,
please.
no. I've been speaking a lot. You go ahead. Yeah, sorry.
No, well, that being the case, Council, I'm trying to figure out what is the
Issue.
dispute. What is the issue? I think the other side has accepted that, you know, the moment the company started paying, is it 8.25%, provided that it seemed to be prospective, then they accept that satisfies the requirement for contribution to severance. They do not accept, of course, that it's retrospective. They say that the company must pay the severance up to the point when there was this differential. You seem to be agreeing with that, and if you are agreeing, I'm just wondering what the issue is.
The anybody who retires under 2018 CBA will be receiving severance and pension benefits from the commencement date of the CBA.
Right. That CBA was one in which both employee and employer were both contributing equally. So there was no contribution by the employer to severance, yes.
Yes. So I don't want to sound ingenuous where basically the facts of the case are that the employer and employee are contributing equally when there is obligation to pay severance. Unless, that is why I said, unless my clients can identify the amount which represents severance, then we have an issue.
That is the itemization alternative.
Yes.
Which on the evidence does not exist. I think you agree.
I agree. That is why we took a hit in the Court of Appeal.
Well, that's a nice way of putting it. Yes, I suppose. You mean you complied with the law? I wouldn't say you took a hit, Mr. Lumor. I think you complied with the law.
We have no choice but to comply with the law.
All right. Okay.
Yeah.
But I think the president's question remains, if I am not mistaken.
Yes, it's not. Sorry, please go ahead, Mr. Lumor.
The point that I am making is that if the issue is that the employees are saying we are entitled to severance, my position basically is, please show the court the section of 183 that confers that benefit on you, or show the court the CBA that confers that benefit on you, or show the court the contract of service that confers that benefit on you.
Well, in all fairness to the other side, you know, Mr. Lumor, they did point to at least two bases on which they could claim severance. From 183.1.1, 183.1.2b, it looks like, and then 183.3. I think those are the two bases on which they contend entitlement to severance, and that is supported, they contend as well, by certain correspondence and certain statements made by representatives of the company.
Those statements that the other side made reference to, the factual situation is that they need, for instance, if we take Section 183 that they said they're entitled to, I, from my speaking notes, support and agree with the interpretation of the three subsections of Section 183 by the Court of Appeal. If the CCJ comes to a determination that those interpretation of 183 1B Roman 1, 183 1B Roman 4, and 183 Roman 3. If the CCJ comes to a determination that the interpretation given by the Court of Appeal to those provisions are wrong, then I'll fall with the Court of Appeal.
So, but
Mr.
Mr. Lumo, I understand. Yeah, so that you really are standing or falling on 183 and whether
Yes.
they qualify, and that turns on the use of the word termination. And your
Yes.
simple argument is on the evidence. There was no unilateral cessation of employment, and therefore the two subsections B1 and 3 that they rely on disapplied because there was no unilateral termination, there was mutual agreement. I think that's the nub of your submission on 183. Agreed?
Agreed, Your Honor.
All right. I want to ask you something, though.
Yes.
Because you see, our brother, Justice Iboye Osuji, raised a point that I think is very important that I would like to come back to, but in a slightly different way, maybe. And it is hinged for me on 190. 190 says, any agreement, I'm just going to come to the point, which purports to exclude the operation of any of the provisions of this part shall be null and void. All right? Now,
That's right.
good. In one, and this is coming to the point that our brother raised.
Yes.
In 183, it is very clear that the statutory referenced retirement age is 60. Correct? That is B4, etc. Agreed?
Agreed.
Good. In this agreement, and the question that he asked was this: what is the implication if, through a collective, a CBA, you opt out of that 60? Suppose you go to 55 or 59. And your answer to that, to my mind, has not addressed as yet the impact of 190. In other words, clearly, and that is why for me the legislative history and the industrial relations context is interested. Why did the legislature, this is what our brother asked, why did the legislature choose 60? Well, speaking loosely in the region, I think that is generally the retirement age of persons in the region, 60. So they chose 60. Does that choice of 60 fall under the umbrella of 190? That is to say, if by a CBA you choose to vary the retirement age from 60 and therefore escape the impact of 183, as you say, because of the construction you give for termination, is that an attempt to exclude the operations of one of the provisions of this part, i.e., that when you come to these labor relation business, 60 is the benchmark retirement age? I don't know if that I framed it clearly enough, but that's something I would like to hear you on.
I understand the question clearly. Your Honor, the retirement age in Belize is 55. even for public workers. And I do not think that there is any breach or sidestepping Section 190 because Section 194 itself gives the employer and employee to negotiate terms under which severance payment should be made. It gives three circumstances: 183, CBA, or contract of service. So I do not think that the legislation itself, by providing for in Section 194 that for the avoidance of doubt, severance payment can be due in three circumstances. I do not think that Section 190 is sidestepped in these circumstances.
Mr. Lumo, if I may come again, return to that matter, but let me first of all try and clarify what divides you now with the appellants. Do I take it that you concede the appellant's position in relation to Section 194? And for you, you can give them 194, what is saying 194, but for you, the debate really lies in 183. Do I understand your position to be that?
My position is that for the employees to, given the facts of this case, for the employees to be able to establish eligibility for severance, they will
that
have
is
to
193. That 183. 183.
183. They would have to come. They will have to combine 194 with 183. You can't, given the circumstances of this case, they cannot go straight to 183. They have to go through 194. Though they say 194 is inapplicable. The reason being that there is no dispute that before the introduction of the pension scheme, all severance have been paid. So the issue now is, during the pension scheme, was the severance an integral part of the pension scheme? If not, was severance paid in addition to pension? Because
But you are saying that the employer needs to show that for purposes of Section 194,
yes,
you want to be able to see that the contributions of the employer would have accounted for severance. Contributions of the employer towards pension would have accounted for severance. And you were saying, well, when contributions are equal, pension contributions are equal, then it means there is no severance. Was that your point?
That's my point.
All right. And that's very much, and Mr. Courtney can correct me if I'm wrong. I think that in essence, I don't think he would quarrel with that view. Yeah. Again, when he starts to reply, he can tell me. So that's why I wanted to know whether you are in agreement with their position in relation to 194. But that aside, now let's come to 183, where you seem to say the case rides. Perhaps one thing that I'm struggling with the prior court, Madam Justice Young, is the basis upon which someone who resigns will be entitled to severance. But someone, you resign out of your own volition. You resign even when the employer may not want you to resign. You resign. And then employers obligated to pay severance.
Yes.
But somebody who retires compulsorily is not entitled to severance. Is that how we're supposed to do harmonious interpretation of statutes?
The as I think the position of the Court of Appeal basically was that this the Court of Appeal just took the position trying to construe Roman 1, trying to construe Roman 4, trying to construe Roman 3, though Roman 3 was not made part of the case of the appellants, and decided to construe whether, given the words of the statute, they're eligible for severance. Because, as the court says, it's a voluntary decision taken by the employee. Therefore, if I look at the words of the statute which applies to you, I am unable to determine that you are entitled to severance.
But Justice Telemedia is asking, and I'm with him on that.
Yeah.
What about Section 190 that says there are just certain agreements that cannot have certain effect? So when the Court of Appeal says, well, the CBAs or voluntary retirement agreements have voluntary bargains the employees make, so they must live with it. Can we say that when Section 190 says, well, it doesn't matter who made the agreement, it simply says any agreement that does certain things cannot have the effect of filling out the provisions of Section 183?
There must be some jurisprudential reason why the lawmakers or the legislator says that your entitlement to severance can be found from 3 sources. The statute, 183. CBA, where the employer and employee negotiates benefits that the employee will receive when there is cessation of employment. And then there is contract of service. I do not, in my respective view, that all the circumstances should be the same as the statute. There could be differences because if we take the CBA and the contract of service, there is an element of negotiation whereby somebody is going to give up rights, obligations in exchange for benefits.
But resignation doesn't give the employer that choice. You resign at age 40, but somebody who's compelled to retire at age 55 is denied the benefits that somebody who resigned at age 40, whether or not the employer likes it, may get.
If that is not in conflict with 183, then it cannot be in conflict with 190.
Okay.
Mr. Noor, can you assist me with B3? Just what's your view on B3? Because we're on whether they qualify under 183, right? So let's just look at B3 together.
That's right.
Mm-hmm. And I know you have a procedural point on this, but let's just not dwell on the procedural point for now. Let's look at the substantive point, please. Yes.
Sure. Yeah.
Over 10 years, we tick that box. Agreed?
Yes.
contracted for a definite period to age 55. Agreed?
Yes.
And the employment is terminated on the expiration of such period, i.e., when you reach age 55.
Yes.
Which I believe on the facts has been satisfied.
Mm-hmm.
And the contract makes no provision or less favorable provision for severance pay. In this case, the CBAs make no provision for severance pay. Agreed?
Yes.
So why are not all the boxes in B3, forget the procedural point, why are not all the boxes in B3 ticked?
Sorry, there is an omnibus provision in the CBA which says that the CBA is subject to the Labour Act or the laws of Belize. So I would not say that the CBA basically excludes the Labour Act.
No, I'm asking something different. Why do you say the facts of this case do not satisfy the statutory requirements under 183B3?
Oh, because as the cessation of employment.
Because the what?
Cessation, because the word they use, cease, from employment to cease.
You say, where over 10 years and his employment, their employment is contracted for a definite period, in this case to age 55,
yes.
And the employment is, they use the word terminated, but they say is terminated on the expiration of such period. Should that word terminated be read to mean ended as per contract?
Yes.
Well, all right. So that even if you have a contract less than 60, you don't come under the 4, you come under 3 because you have a contract of employment under CBA for a definite period. The employment ends on the expiration of that period, and you make no, and this is your section 194 point, you see. If no provision or a less favorable position is made for severance. Remember you said under 194, you had 3 scenarios, 183, CBA, or service contract.
Yes.
So it's saying here, contract ends, and at the end of the period, no provision for severance or less favorable, i.e. less than 2%. My question is, why are these requirements not satisfied? Leave aside the voluntary retirement people for now, the other group 1. Yeah. Why is that not satisfied? And that would take away the dilemma we were having with this 60 age thing. In other words, within the 4 categories, 10 years and over, they have a 60 age category, but they also cater for, well, it's for a definite period of employment. One assumes less than 60 because we've catered for 60, as in this case, 55. And so, unless you can, to be very frank, where I sit right now and on what you've rehearsed with us, I think that the boxes are ticked, but I'm happy for you to show me how they're not.
The issue is whether the contract, in fact, the contract makes no provision for severance or makes less provision for severance.
And we're talking about pre-2021 to 2024 for now. I'm talking about from the 2018 to 2021 CBAs. I believe the undisputed evidence is that they make no reference to severance. I think that's the basis we provided for. I accept that it is arguable that the 2021 to 24 makes reference, but I think Mr. Courtney has accepted that prospectively he is okay with the 2.5 severance. So let's not labor over that. I'm between 2018 and 2021. Doesn't this apply? Aren't the boxes ticked for this?
If there is no provision for severance pre-2021, then the box is ticked.
Yeah. Okay. Good. Thank you.
So you would just fall back. I don't mean to be pejorative when I say just, but you would fall back on the procedural point. I think that you made about the pleading, etc.
Yeah.
Okay.
The pleading issue.
Yes. Did you have anything else to urge on us, Mr. Lamore?
No, I'll rely on the rest of my speaking notes and my written submissions. The reason being that I have supported the decision of the Court of Appeal in its entirety.
Yes, thank you. I noticed you did not even appeal an aspect of the decision that perhaps you could have.
Yes.
Wonderful. Thank you very much. Mr. Courtney, did you wish to say anything in response?
Your Honor, just two things. One is to, first of all, accept the concessions made by my learned friend and to pay tribute to him for the frank way in which he has conducted this hearing. The only other point, Your Honor, is to remind the court that Section 194 is predicated on, to read it, a worker who becomes entitled under any law to a pension. There is no law that calls for the BTL pension. So that's why we were saying that 194, 1 and 2 are not applicable, because that is a scenario where a law called for it, a pension. So it's just a small point, but other than that.
Mr. Courtney, I mean, if I may come in, I'm not sure that point is that small. I may be wrong, but you talked about the Labour Act being a social legislation. Are we required then to identify what the purpose of that legislation is? Could the purpose of the legislation be, as the Court of Appeal identified, to be to cushion employees who, upon a long service to a firm, are not simply given a plaque or a glass commemorative thing and told, thank you very much for long service. What? But at the end of the day, the landlord he's not going to accept your plaque. The landlord wants to be paid the rent or the bank the mortgage. So the employer is given some cushion from in a life put out in the pasture, as it were, from then on. If that is the purpose of the legislation, to ensure that that provision is made, are we free to say, well, that being the case, if employers go on and make extra, give them a lot more. So that's the bonus for the employees. So that's the end of it. So which the employers can then fight if you don't get. So that's one question I have, an overarching question I do personally have in all of this litigation. What is it that article, the Labour Act in Section 183 is seeking to achieve? Has that purpose been defeated in the context of this case?
Your Honor, first point, as I had submitted earlier, and I believe that to some extent it is supported by the Sandy Lane case of the Caribbean Court of Justice. There is inherent in the employer-employee relationship an obligation of trust and confidence, good faith, fairness, and equity. Second point, the Labour Act, in particular these provisions, and specifically Section 190, were introduced a long time ago because of the historical relationship of abuse of employees by employers. And therefore, these provisions are to attenuate, to ameliorate the imbalance between employer and employee. In my respectful submission, the court is to lean in its interpretation in terms of advancing that purpose. The legislature is seeking to ensure that because of the disparity, the employee is not taken advantage of. In the facts of this case, and the reason I complimented my learned friend for his concession, my respectful submission, the genesis of the problem was the bad legal advice in 1995. If the advice had been that these are not alternatives, then the CBAs would have included severance as they had up until then, and the pension fund would have been structured differently, and we would not have the problem that we have today. My respectful submission in advancing the social and the philosophical purpose of the Labour Act requires this court not to have the workers bear the burden and the pain because of bad legal advice from 1995. I say with greatest of respect, in relation to 183, the boxes are ticked for 183.3. Insofar as the resignation is concerned, Ken Santos specifically says the voluntary retirement agreement, those persons resign of their own volition, they qualify under 183.2. As they used to say in the old days, QED.
Okay, Mr. Courtney, two very, very small points before we end. One is more substantive than the other. I do note that the issue of 190 came up a couple times, and the question was raised as to whether the agreement, which basically does away with the retirement age of 60, posed a problem in relation to 190. You may have addressed it before, and I didn't quite hear you. Do you have any views on that point?
Your Honor, I think it has been raised, and one, you will see that Madam Justice Young made the powerful point, which a couple of your brothers have repeated here. If we say that as long as you have an agreement that compels you to retire at 59 or any age below that, and you get no severance, but if you resign at that same age, you get severance. It's an absurdity. The legislation did not intend that, and the purpose of 190 is to preclude that result. You cannot contract to retire at 55 with the consequence that the benefits under 183 are denied you. You're disapplying the section that gives the benefit to the employee.
So 190. Oh, sorry. Please go ahead, Mr. Courtney.
No, I was just going to say 190 precludes that agreement.
Yes. Okay, thank you. And the other is more procedural. We were wondering about the possibility of seeking assistance from parliamentary debate surrounding the passage of the Labour Act, and in particular the sections that we have been considering, whether any report from Hansard might be available that could assist us. I don't know whether you have a view on that, and I don't also know whether Mr. Luxmore has a view on that.
Your Honor, I wear a different hat sometimes. And
Yes.
I would have access to Hansard quite easily. In my experience, these records are kept and they are usually available. I can undertake to try and get the Hansards and to pass them on to the registry and to my learned friend.
Wonderful. Would that be acceptable, Mr. Luxmore? The Lumore, I'm sorry.
Sorry.
Mhm.
It's acceptable.
Yes. Okay, well, thank you all very much. This has been most interesting. And naturally, we will reserve our decision to a date to be announced. And we'll advise you as soon as we are ready to deliver a judgment in this matter. Thank you very much indeed.
Deeply obliged, Your Honors.
Madam Deputy Registrar, would you mind closing the proceedings?
Certainly, Judge. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnatley. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Javada. And thank you, Mr. Justice Osuji. Thank you, Counsel. And a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you very much.
Thank you.